You're listening to Talking Law with Despina Priyala. Now, Despina, can a body corporate make a lot owner pay an excess on an insurance claim?
Super interesting. So this was a recent
Hmm.
case decided by the adjudicator for body corporates in Queensland, 24th of March. So very recent. And it involved a high-rise building in Surfers Paradise called Focus. So Focus is one of the only buildings that's a circular building. It's been around for decades. So it is a very old high-rise. 125 apartments are in that building. So very much an issue in contention and dispute. So what happened was that there was a water leak. Right, so this all stemmed from a water leak, and apparently it was due to a faulty main isolating valve. Okay, so what happened was there was a lot 111 above, and the water leaked from that apartment down below to the apartment 107. Okay, and it caused damage. So there was an insurance claim lodged by the body corporate, and the insurance company accepted the claim. All sounds pretty reasonable. There was, however, a very hefty excess of $10,000. Right. And that was the policy set up by the body corporate. So the repairs were close to 25,000. And that included also that loss included loss of rent. So it was quantified, it was close to 25,000, which was the amount of the damages and loss of rent because the tenant had to vacate from that apartment and the owner lost their income for that period of time. So the issue was who pays for the excess? Now, everybody should know if you've got an insurance claim and there's an excess, nothing gets done until the excess is paid, right?
Hmm.
So the claim can be accepted, but then if the excess isn't paid, then everyone sits around and waits, right, until that excess amount is paid. And that's a big, hefty excess. So what happened here is that the body corporate committee resolved that the owner above, right, where the water leak came from, was responsible for the damage and issued an invoice, but then never bothered to chase up that owner. And then what they said is that the owner below, who obviously was suffering the damage and the loss because the tenant had to vacate, basically said, well, you know what? It's your responsibility to go and chase the owner above to get that excess paid, right? And the owner below was saying, hang on, that sounds unreasonable to me. I don't really like the sound of that. And the body corporate said, oh, well, that's the way it is. So the owner below, right, who was suffering the loss and damage, took the body corporate to the adjudicator's office and issued proceedings in the tribunal. And of course, we have a great outcome. So we want to talk about this. I know we have a short segment, but let's go through some issues because I dare say people listening out there might be in a similar position. It always turns on the facts and circumstances of your case. So don't assume from, listening to this case today that, oh, yes, well, I can make the body corporate do this. And yes, they're unjust and unreasonable because this case said so in that case. Every case is different. Every facts are different. So somehow, in this particular case, the committee, in their infinite wisdom, made the deliberation and came to the conclusion that because the leak was identified as coming from pipework that serviced the lot above only, and that lot owner did not cooperate to enable rectification, etc., then the body corporate just refused to pay the excess. So that was their deliberation. They just said, well, we're going to refuse to pay it. And how is that reasonable when a lot owner can't even take out insurance for items that are already covered under a body corporate insurance policy? So the risk of water damage from one lot to another is covered with the body corporate, but not the lot owner. They can't take out their own insurance. So let's go to the legislation and what it says, because the legislation will govern very much what can happen in these scenarios. So for an event that affects only one lot, right, the accommodation module that applied here says, look, the owner of that lot's liable to pay the excess unless the body corporate decides it's unreasonable for that lot owner to bear the liability. So say, for example, in this case, they talked about a shower screen damage. So if the shower screen's damaged and that only affected that lot, didn't affect any other lot, then the lot owner should probably pay the excess. But they compared it to another example. Say if there was a fire within a lot that was caused by a short circuit in electrical wiring in an internal partition. The body corporate should probably decide it's unreasonable for the lot owner to pay the excess in that situation. So you can see the difference there with the two different examples. So in this case, the adjudicator said, look, this was very much an event that affected two lots, right? So not just one lot. And the body corporate is liable unless the body corporate can decide it's reasonable for the excess to be paid by the owner, right, of a lot, or to be shared between the two owners. And this is what the situation was in this particular case. So under the regulations, right, we talked about legislation and what it says, and that's your go-to initially about what happens in your situation. The default position was that the body corporate was liable because it was an event that occurred between two lots, right? So there was damage from above to below. And then the question was it really reasonable for the body corporate to determine that the excess should be paid by a lot owner based on these facts? And what the tribunal said and what the adjudicator said is that there was no rational legal basis for the body corporate to require a lot owner to pursue payment of excess from another lot owner. So the body corporate said initially, yeah, we invoiced the owner above, right? Said, well, we're not going to chase him for payment. And then the lot owner below said, well, hang on, if you can't pay the excess, we'll get it paid. Then my repairs just sit around and nothing gets done. How is that reasonable? And how is it reasonable to expect me to go knock on the guy's door above and say, hey, can you pay that excess when it's really the body corporate's responsibility?
Yeah, you owe 10 grand.
Yes, exactly. Yeah. And until you pay that 10 grand, right, the damage is sitting there, doesn't get repaired. The adjudicator said it's absolutely not reasonable to make someone wait for extended periods of time in this situation for repairs to be done. It's not reasonable for the lot owner below to be expected to knock on the door above, right, and say, hey, Mr. Lot Owner 111, you go pay that excess. I mean, that lot owner below doesn't really have the power or authority to force someone to pay that excess. It's the body corporate's responsibility. So the outcome is that, yes, the insurance payout, so the outcome was that it was unreasonable what the body corporate decided, and that the body corporate had to pay the excess to the lot owner below, right? Okay. And if it considered that the lot owner above was responsible, then the body corporate should pursue that lot owner, not person below. Yeah, exactly. So that was the outcome. I think it was a great outcome.
Yep. You've got to love bodies corporate, haven't you?
Well, if you think the decision is unjust and unreasonable, you can test those waters and take the body corporate to the adjudicator's office. And in this case, the lot owner did, and he got his excess paid to him, right? So he could get the repairs finished, and that was a great outcome. So yes, sometimes you may have to challenge the body corporate.
Yeah, that's it. All right. Well, thank you so much again for coming on the show, Despina. If anyone does want to get in touch with you or anyone at Priala Legal directly, where can they go?
So they can phone the office 55291294, 294, or they can email info@prialalegal.com.au, and this will be up on YouTube later in the week.
Thank you so much, Despina and Wayne.
And we'll do it all again next week.
See you then.
Are you confused about legal jargon? Do you need legal advice but don't know where to turn? Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97. Despina, a leading lawyer with over 20 years of experience, will demystify the law and provide practical advice to help you navigate legal issues. Whether it's a family matter, a property dispute, or a business concern, Talking Law has got you covered. Don't miss out on this valuable resource. Tune in to Talking Law with Despina Priala every Thursday morning at 8:30 on Radio 97.